All rise. Ladies and gentlemen, the Florida Supreme Court is now in session. Please be seated.
We will now take up Citizens of the State of Florida versus Andrew Giles Fay, case number 2022-1733.
Thank you and good morning, Your Honor. May it please the Court and Counsel, my name is Allie Westling and I represent the Florida Office of Public Counsel as well as the customers of Florida Power and Light, Duke Energy Florida, Tampa Electric Company, and the Florida Public Utilities Company. I'll start by acknowledging that there are a lot of briefs and large records in this matter, but what I want to be very clear about is that OPC's argument throughout the litigation and throughout this entire appellate process is the same. The Commission has failed to fulfill its legislative mandate of ensuring that utility investments are prudent and cost-effective.
Well, I think first we have to establish whether that mandate needs to be effectuated now, at this point, at this juncture, or whether the appropriate standard is a public interest one, and if those two things are different, how they're different. So perhaps you can say a little bit about the difference between the public interest review and the prudence review to the extent that you think there is a difference.
Certainly, Your Honor, and there has been a lot of case law on one of these issues separately and together, but overall, Chapter 366, as the Court has recently stated, is governed by a public interest standard. The whole chapter is in existence for the public interest, and within that chapter, 366.06 specifically requires a prudence review. So, to the extent that a prudence review is required to fulfill
How are they
the public
different?
interest.
Are they different?
They are different, Your Honor, but you can't have one without the other. The Court has previously stated in the Sierra Club case that imprudent investments of millions of dollars would likely conflict with a public interest finding. So
that's true, but in Sierra Club versus Brown, we still embrace a public interest test.
Yes,
and then make that note about what would likely be true. Here, the Storm Protection Plan statute is a little different in that we have a chronologically staged review, right? Every 3 years, we've got sort of a different test than we do ab initio. That seems to me to reflect, in the structure of the legislation, a choice about what to do. There is no mention of prudence ab initio. It shows up in the 3-year, refresher, if you will. Don't we ascribe to that legislative choice some meaning, or is it, from your perspective, indifferent?
I would respectfully disagree that the issue every 3 years is strictly public interest, because prudence of investments in every single docket in front of the Commission is a statutory requirement in the absence of a settlement agreement, as the Court has stated in Sierra Club. So prudence of investments in rate-making dockets, which include the SPP and the SPP CRC process, prudence is always required. And as the Court is aware, these cases were heavily litigated. This was not a settlement agreement situation. The prudence of these investments, as required by 366.061, it always applies. And specifically, Chapter 366.96, the SPP statute, does not contain a notwithstanding 366.06 statement.
But why isn't the to the extent that the statute tells the Commission that in its review of these plans it has to factor in the estimated costs and benefits to the utility and the customers of making the improvements in the plan, why doesn't that sort of bake what you're worried about and calling the prudence thing, why isn't that sort of baked into this? And to the extent that the Commission, abused its discretion because it, kind of arbitrarily ignored that, or, if there weren't competent and substantial evidence. I mean, isn't that, it seems like we have a very specific statute that does embody this principle that you're worried about. And, because the statute says that once the plan is approved, the way I understand it is then when you get to the cost recovery part, people can argue about whether the plan was implemented in a prudent way, but you can't sort of at that stage question, well, why were you doing this in the first place, right? You did it perfectly, but it was imprudent. It seems like that argument gets taken off the table. So why isn't what your concerns, which are, understandable and valid, why is it not just handled through, following the statute and making sure that the commission considers this criterion the way it's explicitly told to?
And that's exactly our issue, Your Honor. We agree that the statute is clear, that the statute, when read harmoniously with the always requirement that prudence be considered, that the statute is clear. It's the commission's interpretation, which must be subject to a de novo review, that is the problem here. The commission did not properly conduct the cost effectiveness evaluation that is required by the text of 366-96 and the rule that the commission wrote. We have no problem with the statute. We have no problem with the rule. We have a problem with the way the commission has interpreted both.
Okay, so then instead of sort of having this sort of metaphysical argument about prudence and statutory interpretation, it seems like you need to be making a specific argument about whether you characterize it as abuse of discretion or lack of competent substantial evidence. What's your specific argument as to, and I guess not all of the utilities are in the same boat, right?
Correct.
According to your view of the case. So, I mean, what specifically are we supposed to be, if we accept that this cost-benefit review, whatever you want to call it, is embedded in sort of the, the statutory framework, then what did the commission get wrong? I mean, what's your argument about what they got wrong specifically?
There are a couple of things that they got wrong. As you identified, they found that all the companies complied with the SBP rule requirements when there is not competent substantial evidence of that. 2 of the companies did provide the required information, and 2 of them did not. So that's one issue.
Okay, so can we take the other 2 then off the table?
No, Your Honor,
Okay,
because
why
not? The commission found explicitly that prudence was outside the scope of the SPP proceeding, and they found that as it applies to all 4 cases. So even though these utilities, the 2 utilities who did comply with the rule and the statute provided the information, when the commission found that prudence was outside the scope of the SPP proceeding, that affects all 4 dockets.
But did they say that cost-benefit comparison is outside the scope?
They didn't say the cost-benefit analysis.
Because that's the question, right?
Well, yes,
Under the
Your Honor.
statute.
What they did say in each order is that neither Section 366-96 nor the SPP rule explicitly require a cost-effectiveness evaluation or quantitative cost-benefit analysis. That's what the commission found, and that is our ultimate argument, that the prudence and cost-effectiveness that is mandated by the legislature to be conducted was ignored, and the commission abdicated its responsibility to conduct that analysis.
Just making sure I understand. So you're saying even where you have the statute, where there's a very clear sort of bifurcated process that uses very specific words, for this first section, it's public interest. For the second part, and that part has to have a very specific cost-benefit analysis, very specific. And then the second part, which requires the 3-year and prudence and all of that, that somehow we sort of assume that there's something else that the legislature intended that overlays that they just did not really include in their sort of detailed procedures.
I don't know if assuming maybe is the right word, but if you look at subsection 7 of the SPP statute, it says that proceeding with actions to implement an approved storm protection plan shall not be evidence of imprudence. That shows the legislature's intent, especially knowing that they already had 366 in place and no notwithstanding.
Except that the first word in 7 is after. After a utility's transmission and distribution storm protection plan has been approved, proceeding with actions to implement the plan shall not constitute or be evidence of imprudence. I guess what I'm getting at is I get your argument that there is a statutory overlay of prudence. I don't dispute that. I instead see a very finely wrought statutory scheme that assumes that we know that there is that overlay. But here's in 366.96 speaks more specifically to a new process, this SPP process, and it balances the statute's overarching interests in prudence and public interest in a specific way, by doing a public interest determination ab initio, and then, again, to quote the statute, after a utilities transmission and distribution storm protection plan has been approved, evaluates it for prudence. Am I missing something?
My understanding that I think would answer your question, Your Honor, is that specific statutes only override or take precedence over more general statutes when there's a conflict. We do not allege that there's a conflict between the overarching, ever-present requirement for prudence and the requirements that that these plans be in the public interest. As I said, public interest is the point of the statute, and there's still a requirement that prudence be conducted.
I don't understand. I guess I just don't understand why you're even doing, first of all, the 366-061, it's, this isn't a rate-making thing when you're talking about approving the plan. I don't understand why you're introducing this kind of overlay of that when, this doesn't just say public interest and it's up to the, you could imagine a statute that said public interest and it would be a much less bounded sort of act of discretion. I mean, here we have a public interest standard that requires the consideration of these specific things. One of the things is this cost-benefit thing. It just seems like really the whole argument should be kind of focused on just this statute rather than having what I think is kind of a distraction about whether the other statutes, you need to harmonize them. I mean, this is a very specific thing.
So there's 2 points that will hopefully address your concern. The first is that we do believe that the storm protection plan process is rate making. Our reply brief goes into this in greater detail, and I know the court's preference for brevity, so I'm not going to repeat all of that, but we have very clear, strong points about why the SPP process does constitute rate making. The commission is dealing with, they are setting budgets in the SPP process. They are setting billions of dollars worth of budgets. They are pre-approving the expenditure of billions of dollars that customers will have to pay for in the SPP process. And the SPP process and the SPP CRC process are inextricably intertwined. The utilities cannot recover a single penny from customers without both of those processes having taken place. They both result in the charge that shows up on customers' bill every month. The SPP process is rate making. And again, I'll rely on our arguments in the reply brief that also further support that point. But
the rate making aspect of it only happens in the second phase. I mean, the explicit rate making phase of it, right?
I would disagree, Your Honor.
You think the table's set by the first phase?
Correct.
And they're
Your
kind of
Honor.
boxed in.
Correct, Your Honor. And like I said, customers or the utilities cannot collect a single penny without both of those processes taking place.
Would you help me understand something? How do you quantify the benefit of a reduction in outage times?
Your Honor, 2 of the utilities did so. I can give you some record sites if you'd like, but they are actually all reflected on the initial brief, page 37. That's where we identify that Tampa Electric Company and Duke Energy of Florida, they hired outside consultants, and those consultants went through a rigorous process. I hate to give them credit, but they went through a rigorous process of identifying how to put a dollar number on those benefits, and they did so, and they provided that information consistent with the requirements of the SPP statute and the SPP rule. Unfortunately, 2 of the companies did not provide
You
that
put a dollar,
information.
but in some ways, I understand you can do some magic and come up with dollar numbers, but you're really kind of comparing things that are different sorts of things, right? I mean, once you put a dollar number on it, you compare dollars, huh? But there does seem something kind of mysterious or arbitrary about that.
Well, one thing that I think is important to recognize is that the benefits of storm protection and of storm hardening are laid out in the statute, and we fully agree that storm hardening is a good thing. Reducing outage times, reducing restoration costs, that is a good thing, and whether we agree or not, that's what the statute says. So the qualitative benefits of these storm protection plans are already encompassed in the statute. What the statute requires is quantitative information about how these SPPs will actually benefit customers and how those benefits relate to the costs. So the quantitative nature of the word estimate, which again is in both the statute and the Commission's own rule, that shows how the degree of specificity that's required in order to have an accurate comparison of the costs and benefits.
But you know what it says in the rule? It talks about a description that including an estimate of the resulting reduction in outage times and restoration costs due to extreme weather conditions. I'm trying to see here in the text of the rule, which you're not challenging the rule. I mean, you're
Correct.
You're going to operate within the rule. I'm trying to see where you get to a requirement for a quantification of that element.
Our view is that is embedded in the word estimate, because again, the qualitativeness of the benefits is laid out. It is the statute.
Well, I understand. Estimate does imply something quantitative, but what could be quantitatively estimated there is we're going to reduce outage times by 20%. That doesn't say anything about a dollar value, or we're going to reduce it by X number of days. That's what comes to my mind when I read this in context. Where other places they're talking about cost, I'm just struggling to really see the requirement for something quantitative, a dollar quantity associated with that, which is what you say is required.
Yes, Your Honor. So the dollar cost is required in the same rule, but when you're talking about the estimates of the reduction in outage times and the reduction in restoration costs, obviously the restoration costs would be in $1, and the other would be in a number of minutes. And two of the utilities provided, they did that quantification. They analyzed their plans, what those plans were meant to achieve, and they came up with minutes. They came up with the number of minutes that would be reduced and the restoration costs that would be reduced. So it is possible. Half of the companies did it, but half of them didn't.
Okay, how do you compare? Well, so there's not a monetary element to that. It's purely a quantitative assessment of time.
Yes, Your Honor.
As
And
opposed to a more qualitative.
I would say it's objective rather than qualitative. Maybe that's a better word to use. But having objective numbers that can be compared to objective costs and then analyzed for cost benefit.
But I don't know, that's really not comparing minutes to the cost in dollars. I don't.
Yeah, I guess
I don't know how you compare that. Those are incomparable things, really.
This goes to the same point I was trying to articulate earlier, but I think that Justice Kennedy has done a better job than I have. What does the order, if you prevail, what does the order on remand say?
We ask that the order on remand require the Commission to fulfill the legislative mandate of holding the utilities to the requirements of the text of the statute and the rule, and to conduct this prudence and cost-effectiveness evaluation to ensure customers aren't paying for these billion-dollar investments which are imprudent. That's what we are asking for.
Are they presumptively imprudent? Like, why are we presuming that they are imprudent at this time?
As it stands right now, we don't know. They're not presumptively prudent or imprudent. It's because the Commission failed to conduct the review that we don't know that. The harm to customers right now is not that they're paying for imprudent investments, it's that they could be paying for imprudent investments because the Commission did not do its job. And I'm not sure where I am on time, but
You have 2 minutes and
I'd like to reserve
10
the rest
seconds
for
or so
rebuttal,
left.
please.
Thanks.
May it please the Court. Good morning. I'm Susan Saposnikoff on behalf of the Florida Public Service Commission. This Florida Public Service Commission asked to take 10 minutes of today's time, with my esteemed colleague Dan Norby reserving the remaining 10 minutes on behalf of the utilities. This Court should affirm the 5 final orders in this consolidated matter for 2 reasons. First, the Commission correctly interpreted and applied the plain language of Section 36696. And second, the Commission correctly interpreted and applied the plain language of Rules 25-6.030 and 25-6.031. 36696 is a very specific and a very unique statute. In the statute, the legislature requires electric utilities to develop plans to engage in specific storm hardening activities designed to make the electric grid more resilient during extreme weather events, and it also sets forth specific criteria the Commission must use to determine if the utility's plans to accomplish those activities satisfy the statutory mandate and whether they're in the public interest. Moreover, the statute holds that once a plan has been determined to be in the public interest, the Commission must conduct an annual storm protection cost recovery clause proceeding to determine the utility's prudently incurred costs and allow the utility to recover such costs through a charge separate from base rates.
So can I stop you right there?
Certainly.
So the point of that second proceeding is to see whether the plan that was approved has been prudently implemented. So you could have a plan that by design makes sense and would be cost benefit rational, but you then go and actually implement it in a way where you waste money doing it, or you hire a bad contractor, or you mismanage the project or whatever, and that could lead to sort of variables in what kind of cost recovery you have, right?
Oh, exactly.
Okay, so you agree that the statute itself requires the Commission to take into account in some way whether you have a rational fit between the costs of whatever this proposed plan is and what the benefits are going to be, some of which can probably be quantified in dollar amounts, like reduced, costs of, whatever the replacement power, and then the downtime, which probably people try to put, dollar values to, but might be more difficult. But you agree that the rationality of the fit between whatever the plan is and what that's going to cost and what's on the other side for benefits, you agree that that's part of the first phase review, right? The plan, the review of the plan itself.
Correct. The legislature put forth very specific factors that the Commission had to consider, and those entail looking at costs, looking at benefits, looking at projected rate impact. But when we're at the plan stage, these are 10-year plans, and the statute only asks that we kind of set forth a general roadmap. The rule came in with more specifics. But when we're looking at public interest, the legislature set forth what the Commission had to consider, then that gives it the information to move into that second phase when you're looking at whether or not they actually prudently did what they told the Commission they intended to do.
And so explain to us what is the difference between your understanding of what the Commission is supposed to be looking at and what the utilities are supposed to be kind of laying the foundation for, versus this prudence review that counsel on the other side is asking for?
Certainly. The Commission has a long-standing, decades, I think back at least to 1982, and it's been supported by this court, a well-established definitions of what prudence is. It looks at what a reasonable utility manager would have done given the information it knew or should have known at the time when it made its decision, and it goes to incurred costs, and even our statute talks about incurred costs, which is a backward looking to costs actually done. Now, if we want to use prudence more in the colloquial sense about, is this reasonable, is this appropriate, is this a good thing to do, is it meeting the state's interest under the statute, that could be called prudence, but it's not a prudence review. So the legislature clearly said the Commission had to perform a public interest determination in the first hearing. Then when we switch over to looking at the actual costs, there's consistent review as to whether or not the managerial decisions that the utilities are making are being done prudently.
Okay.
So what, if I understand what you're saying, is that the prudence determination really is a determination that is more appropriate to look at the implementation phase,
Exactly.
as opposed to the long-range plan phase.
Yes, sir.
But you also would agree, though, that once the plan is approved, when you get to the cost recovery phase, the public counsel would not be permitted to come in and say, well, why did it doesn't seem like this was, the bang for the buck that you get for having done this or that thing, even if you managed it perfectly and, didn't waste a penny in implementing that. Do you agree that under this statutory framework, that type of argument that goes to, like, is it rational to have done this in the first place, that by the terms of the statute, that is taken off the table? Do you agree with that?
Right, because they should have made those arguments during the plan hearing and come in with evidence as to whether or not the plan.
So then in other words, so you agree, and obviously the question is going to be, did the Commission do it here? But you agree that the sort of the rationality, the reasonableness of planning to do these projects and spend these estimated amounts of money in exchange for what the benefit is, that's all part of the sort of first step review of the plan, right?
Right, but in terms of we have our plans, and then those have programs, and then the programs have individual projects. When we're looking at the plan stage, it's very, it's 10 years out. So the statute and the rules set forth specific things that need to be looked at the first year, going 3 years out, and then for the rest of the plan. And then as those come back and get revisited at least every 3 years, those plans are going to come back before the commission. Things get updated, things get reassessed, and that's the opportunity to come in and talk about whether the concept of what you're doing is appropriate. Now, even if that concept is appropriate, you can still come back and challenge how those were implemented in the cost recovery clause phase. So there's, multiple portions where this is an ongoing assessment of reasonableness and whether the actions were prudently taken to get to those objectives.
So the commission then basically, under the statutory design, the commission has to be smart about the extent of its approval, because once it can say, this sounds pretty good, but we're only going to approve in terms of like locking in the wisdom of doing certain aspects of this plan, we're only going to approve this part of it, and then to the extent that you're projecting 10 years out, we'll get to years, 3 and beyond when you come back for your update. But essentially, once you have sort of blessed the, the wisdom of a particular project at that level, then essentially that then is kind of set in stone, and really the only thing that's left to fight about in the cost recovery phase is just the actual kind of managerial sort of efficiency and effectiveness of how that was implemented. Is that fair?
Essentially, yeah. The programs are, and the projects are, in some extent, less or more, depending on how far out they are, given some approval at that plan stage. But then when they come in, the first year in cost recovery, that's going to be reassessed. Maybe a utility started a project and decided not to go forward with it because of cost concerns that came up. If they did go forward with it, again, whether or not they're making prudent decisions and implementing that are still constantly going to be assessed. The language of this statute doesn't make the scrutiny with which the management decisions to implement these projects, it doesn't make it any less. As a matter of fact, if the OPC got what it's asking for, essentially, that prudence was done at the first stage when we just sort of have this very far-looking information ahead of us, that would then preclude any sort of further review in the cost recovery stage. Because prudence is a finality, and if you look at the statute, it talks about, make sure I get the language correct here, that if the commission determines that costs were prudently incurred, those costs will not be subject to disallowance or further prudence review absent certain circumstances. So if we were to make a prudence determination at the plan stage with this far-looking, not nailed down incurred costs, that would then preclude OPC from coming in the second stage and challenging these management decisions, which I'm sure is not what they want. Any further questions? All right, well, for the reasons stated in our brief and argued here today, we will respectfully request this court affirm all 5 orders. Thank you.
Thank you.
May it please the court, I'm Daniel Norby from Schutz & Bowen on behalf of Duke Energy Florida. In the interest of efficiency, I'll be presenting argument on the legal issues that are common to all of Florida's investor-owned utilities. But if the court has specific questions about the record of any utility other than Duke Energy, I'll defer to counsel for that company for those specific questions. Based on the questioning so far, it appears that the court understands our arguments based on the statutory text and structure. That Florida's Storm Protection Plan statute establishes 2 distinct proceedings at the Public Service Commission, each of which is governed by different standards. The Office of Public Counsel's interpretation is contrary to the text and the structure of 366.96 and should be rejected on that basis. I'd like to start by actually addressing the cost recovery order that is here as part of the consolidated appeals, because the Office of Public Counsel in their briefing has not raised any independent challenges to the elements of cost recovery that the Commission awarded to the utilities here. The only issue is this overarching argument about the Commission not conducting a prudence review in the separate plan approval proceeding. But there's nothing in Public Counsel's briefing, for example, challenging any item of cost recovery and arguing that there's no competent substantial evidence supporting recovery of that element. In fact, they didn't even raise those arguments below. So as we've outlined in our brief, those arguments are not properly before the court. They've not been preserved. They've been waived on appeal, and they should be approved on that basis. To the extent the court wanted to look in the record for competent substantial evidence, there's ample evidence in the record, as we've outlined in our brief, supporting each element of the cost recovery order. On the Storm Protection Plan approval order, the Commission's final order here outlines each of the 4 factors in subsections 4A through D that the Commission is required to consider before determining whether to approve the plan in the public interest. And the Commission here did that. The Commission's order here explains each of those elements, the standard that applies, the evidence that was presented, and those are the factors that the Commission must consider in determining whether the plans should be approved in the public interest. The prudence determination statutorily by text and structure comes into play, as Chief Justice Muniz said, in the implementation stage. How the utility implemented an approved storm protection plan, if it did it in a way that was imprudent. And we've given examples in our briefing of ways that a particular implementation may be imprudent, but the decision to engage in transmission vegetation management, as outlined in a plan, is not subject to an after-the-fact review at the cost recovery stage.
So prudence in this area is kind of a term of art, but you agree that sort of the cost benefit, sort of, does this make sense? Is it a rational thing to undertake this plan? I mean, that is part of the initial review of the plan, right?
Oh, absolutely. Paragraph 4C of the statute requires the Commission to consider the estimated costs and benefits to the utility and its customers of making the investments proposed in the plan. So that goes into the mix of public interest determination separately from a decision of prudence, because as the Commission's counsel explained, the prudence review that the Commission determines is a review of costs that have been incurred to determine whether the decisions that have been made or the costs that have been incurred are consistent with what a reasonable utility manager would have done in those circumstances, backward looking. A prudence review does not, in the traditional prudence review, the Commission does not allow for a determination of what will happen 8 years in the future under a plan that's described in general terms, and will be back for a renewal.
And so to get to their other point then, obviously if you have things that can be compared apples to apples, you can kind of do the dollar thing. What inputs does the Commission need to be able to rationally do a cost-benefit analysis? And I don't use that in any kind of hyper-technical sense, but just sort of what a reasonable person would consider to be kind of a sense of it. What are is it worth, what I'm getting out of it, is it worth it? What data do they need, or information do they need?
Sure. So each utility here, this was the first fully adjudicated storm protection plan proceeding. Each utility chose to present its evidence in a slightly different format, and we don't quibble with the methodology applied by any particular utility. What the rule requires and what the statute requires what the rule specifically requires a description of the costs, a description of the benefits, and a comparison of the two. What neither the rule nor the statute requires is what you might consider an economic cost-benefit analysis, where the benefits have to outweigh the costs in order for the plan to be approved. And that makes good sense given what we're considering here. It may be costly to employ storm hardening in the Tampa Bay region, but you wouldn't say just because we haven't had a direct Category 5 hurricane impact in Tampa Bay that there are no benefits simply because there was no need for those hardening measures to take effect. We didn't have customer interrupted minutes. So neither the statute nor the rule is particularly prescriptive in what sort of evidence the Commission can evaluate in making those decisions. The Commission here evaluated the evidence produced by each utility and determined that that as one of the 4 factors was sufficient to find it in the public interest.
And so can you help us understand, because obviously we're going to be setting precedent here for how we review these things, and one of my sort of things that's a problem with all of these PSC cases is trying to make sense of our case law on the connection between these decisions that the PSC makes and the standard of review. So if I were writing on a blank slate and I have an agency that's being told to make a public interest determination, I would look for sort of a reasoned explanation of why the agency thought that whatever they're approving is in the public interest. And to the extent that that explanation relied on sort of factual findings, I would look for competent substantial evidence to back up the underlying findings. But I don't think that it makes sense to just sort of have an agency assert that something is in the public interest without explanation. And I'm not saying that that's what happened here, but without explanation. And then we're supposed to kind of comb through the record to see, are there facts in here that a rational person might think? Because then we're sort of replacing the agency as the one sort of doing the thinking. So when we're reviewing this, what is your understanding as to what it is that the agency is supposed to do, and then what are we supposed to be looking for in terms of reviewing it? So do they have to give an explanation of, for example, like in the hypo that you gave, you know, yes, it's all these costs, and yes, there hasn't been a storm in 10 years, but, you know, if there were a storm, it would have this, you know, catastrophic effect, and therefore it's reasonable, blah, blah, blah. Do they have to give that kind of an explanation, and then do we look for the underlying facts to be supported, or is there something else that we're doing?
Well, certainly agree that if the commission is making, or any agency is making factual determinations, that this court reviews that to determine whether there is any competent substantial evidence in the record to support those factual findings, notwithstanding that there might be evidence in the record that would support the opposite view.
So is the public interest determination a factual finding?
The public interest determination, I think, has a mix of two different things. There's an aspect of it that is a factual finding and would have to be based on the other aspects of that are outlined in the particular order here, and whether the facts are supported in the record. A public interest determination, though, also is infused with some policy considerations. The commission is established as the expert agency on this area, and they apply policy reasoning in addition to those facts to arrive at that determination. The Administrative Procedure Act does not explicitly require what you've suggested is a reasoned explanation for why they applied their policy in that particular way.
Why isn't it implicit, though? Because otherwise, what's the point of having these experts who can, you know, intelligently sort of consume all this data and then make a reasoned determination of what is in the best, you know, public interest of the state? I mean, either you guys aren't doing, not you, but her, or we're wasting our time here, because if all it is, because obviously anybody can put anything they want in the record, and then if the agency can just assert this is in the public interest, and we're supposed to go and say, well, if they believe such and such witness, it's over, then it just seems like this whole thing is a waste of time.
So I would agree to one extent. I'd agree that the public interest, an evaluation of the public interest determination is a very deferential standard of review. It must be based on the record. If an agency puts something, it establishes, says that something is in the public interest for reasons that are not supported by the record, that would be a basis for this court to decline it. Or if it determines that something is in the public interest based on a consideration of factors that the statute prohibits the agency from considering, that would be a basis for this court to review. In this particular case, though, what we have is a public interest determination, and we have each of the factors considered in this order. This order, the one here today, isn't, for example, an order of the commission establishing something with no discussion of a major issue that was disputed between the parties below. This order outlines each of those, and this court may have seen some of those in prior cases. We see them a lot. And I guess that's the thing. I'm just trying to understand what we should be setting as a precedent for what we're going to do here. Because if we have another area of the law where we have a discretionary decision that we're reviewing, and then we're just sort of like mindlessly saying that we're going to apply competent substantial evidence, it just seems like we're setting up, you know, yet another area of the law that makes no sense. So I would say just two brief responses, if I may, on time. One is if you're writing on this, I would ask you to write that it's a deferential standard. It's not a standard that is without any limitations, but it's a deferential standard because it's a mix of a fact determination and a policy determination, and also an emphasis on the fact that it is the burden of an appellant to identify issues of sufficiency with an order on appeal. That is not an aspect of the challenge that OPC has raised here. They've not challenged the sufficiency of the order in its explanation, and so for that reason, we'd ask that that one be affirmed, both the storm protection order and the cost recovery order. Thank you.
Thanks.
Thank you. And I want to point something out that is a clear issue here. If I understood what the Commission and Counsel for Duke represented, is that they agree that a cost-benefit analysis of some sort should be done in this matter. However, that is not what happened in these cases. The Commission stated in all 5 orders that no cost-benefit analysis was required, and they did not conduct one.
Let's go to the rule. So 25-60303 sets out what gives some meat to what we're talking about. We've been having a fairly abstract discussion, but there is a list, a description of each proposed storm protection program that includes, and then it enumerates 5 factors. The one I will focus on is number 4. A comparison of the costs identified in subparagraph, the one above, and the benefits identified in subparagraph, the one above. So comparison. The rule requires a comparison. So instead of saying a cost-benefit analysis, let's take the rule. Is it your position that in the 40-some thousand pages of this record, there's no comparison of that nature?
No, Your Honor, there's not. The Commission did not conduct an evaluation of, especially with Florida Power and Light and FPUC, because those utilities didn't provide the estimates that were required by this rule. But when you look at the orders themselves, even the headers for the section in each order, it says, what are the estimated costs and benefits?
Is Counsel for Duke wrong? Do you, in fact, challenge the sufficiency of the explanation given by the Commission in this case?
Yes, Your Honor, because they did not consider the prudence or cost effectiveness of any of these plans. So what I was saying was that the Commission asked, what are the estimated costs and estimated benefits? And the conclusion paragraph in each of those sections of each order is that the costs are X and the benefits are X if they were even provided. The PUC order didn't even list what the benefits were because those weren't provided. They did not consider anything. They just said, what are the costs, what are the benefits, and moved along with the order. They did not consider prudence. They did not conduct an evaluation. They did evaluation, comparison, analysis, whatever you want to call it. All they did was essentially treat the statute like a checklist and say, these are the costs, these are the benefits, we stamp this as being in the public interest. No analysis was done, and that is clear from the record. I understand that certain parties are agreeing that the analysis is required, but that is not what happened here, and the record is clear about that.
I don't really read your brief, though, as raising the specific issue about the sufficiency of the explanation. I mean, I know it's got a little bit of the jurisprudence here is a little bit of a moving target, but I don't really view you as making the kind of argument that you're being asked about.
We argue that the sufficiency of these orders, or that these orders are insufficient because they did not conduct a prudence and cost effectiveness evaluation as required by the text of the statute and the rule. So these orders are deficient and insufficient because they do not carry out the legislative mandate that the Commission is required to carry out by ensuring that the prudence of the utility investments that are passed along to customers are prudent. That's the root issue of the insufficiency of these orders.
Is there any other situation where that prudence determination that you're asking about is done prospectively?
Yes, Your Honor.
And where was that?
So within our initial brief, I believe it's the second argument, there are situations where prudence is done prospectively. For example, in that situation, it was there's a statute, it's for nuclear and integrated gasification combined cycle plants. And the Commission is required, and we included a quote where the Commission stated that when you're looking at prospective investments, prudence is what's at stake. Prudence is what needs to be determined. And the Commission said that when they considered this prospective, whether or not they should approve this plant. This is a storm protection plan. This is a prospective review that the Commission must conduct. And the prudence of this plan is required by all parts of Chapter 366. And again, I know I've harped on this before, but the fact that the legislature did not include a statement at the beginning of the storm protection statute to say, notwithstanding 366.061 and the prudence requirements there, here's what the commission must consider. The legislature used the word notwithstanding 16 different times in Chapter 366, and not once did they say that word in the storm protection statute. The prudence requirement of 366.061 is essential to the commission's job.
But in the statute, the statute we're looking at does talk about prudence. It just talks about it in the second phase.
But that doesn't mean the first phase isn't also
Well,
subject
but when they talk about public interest there, and then they talk about prudence, it's not like the legislature forgot prudence, or that there's somehow they're acknowledging there's this overlay. They're making some distinctions about the way this particular process will roll. And it seems to me, just from looking at it and looking at that text in context.
Well, in order to find that something is in the public interest, it has to be prudent.
I know, but I think you're getting yourself off track by using a term that has this kind of specialized meaning. I mean, your point is that it cannot be in the public interest if there's not a rational connection between the costs and the benefits.
Yes, Your Honor.
Right?
Yes, Your
okay. And that's totally within the four corners of the statute. You don't need to get into 366.061, whatever. You have 30 seconds.
Yes,
to
Your
finish
Honor.
up.
I would just close by saying that the SPP statute authorized an additional form of cost recovery for utilities, but it did not absolve the commission of its responsibilities, of its otherwise responsibilities. The Florida Public Service Commission has abdicated its responsibility to conduct this cost-effectiveness requirement as required by the text of the statute and the rule. And OPC asks that this court reverse and remand all 5 orders back to the commission so that the commission can do their job, conduct this cost-effectiveness evaluation, and determine the prudence